You may be seated. Hey, good afternoon. This is Lori Shavlik versus Dawson Place. Are the parties ready?
Yes.
Yes, Your Honor, and just for the record, I would like to know that we do not have any objection to Mr. Jovie and Ms. Block videotaping.
Oh, all right then. Do the parties consider it prudent to take the motion to recuse first?
Yes, Your Honor.
All right, Ms. Shavlik. You can come forward if you wish.
Thank you. Your Honor, when this case started, you had made a mention in front of everyone that you yourself worked at Dawson Place, and at the time, I was not aware of the actual involvement that you had at Dawson Place. And during this process, I was attempting to do a legitimate inquiry into whether or not Dawson Place was a public agency. The information that I came across were emails relating to David Fontenot, Kendra Connolly, and Adam Cornell. It urged me to seek a deposition to further inquiry. So as I was doing these things, the Snohomish County actually tried to interfere with those subpoenas and depositions. Without ever really considering the information that I came across, such as the emails, it was really quickly hushed up that I shouldn't have these subpoenas to learn more information. But what we did find out after we made your decision was that Adam Cornell was also deposed in another case where he admits that he works with Dawson, inside of Dawson Place, with Kendra Connolly and with David Fontenot. And he acknowledged those emails regarding David Fontenot and Kendra Connolly handling evidence, specifically a DVD evidence, where we, Arthur and I, were doing depositions for Ty Tierney, Lori Vanderberg, Mark Rowe, and everyone did not answer that question where we were discovering where is the property kept, who has possession of the evidence, how do they collect the evidence, who maintains control of what happens at Dawson Place. And the process of this was what we were trying to discover. Through these discoveries, it was learned that I was sanctioned on February 1st by you for doing a deposition of Adam Cornell that was a subpoena issued for that service. I had a legitimate reason to do a deposition of Adam Cornell. And I did in fact discover that he did in fact work with Kendra Connolly and David Fontenot inside of Dawson Place. And that was the whole reason for discovering how does this DVD, who handles this DVD? And where's this DVD kept? And nobody that we did a deposition for could ever answer that question until I deposed Adam Cornell. And they had discovered, oh yeah, that was my email. And Kendra Connolly did have possession of the DVD. And the prosecutor and the sheriff are working together to collect evidence to use in a criminal trial, in which you yourself, Your Honor, have a Raymond Air Baines case that came back from the Supreme Court says due process was in violation. What I'm asking for now is that I would ask that you consider the fact that at the time that I acknowledged that you could have this hearing and be a judge in front of this hearing, I was not aware of the involvement that was in the county and the cases that you were involved in. Surely that through these cases that I must have came across 10 cases where you had listened to witnesses and testimony regarding where the DVD was, who had possession of the DVD. You signed protection orders for the DVD. Your knowledge was a lot more than what you led us to believe. And I'm asking that you yourself would consider that led me to have not a fair hearing. I didn't get a fair chance because I feel that you were prejudiced by your personal relationship and that being your job in the past. That's what I would ask you to do, is to not hear any other, make any more orders or issue any other thing until the Court of Appeals comes back and I get a fair chance to know whether or not that $3,000 sanction that you put on me myself was prejudicial and improper.
Okay, all right, thank you, Ms. Shavlik. Yeah, Mr. Myers.
Good afternoon, Your Honor. Jeff Myers for Dawson Place Child Advocacy Center. Dawson Place is a 501c3 nonprofit corporation. It is a legal entity. The plaintiffs in this case don't seem to ever get the fact that that is an entity that they have sued that is different than a building where the prosecutor has offices, where the sheriff has offices. Dawson Place was incorporated in 2009. You became a judge in 2008. To my knowledge, you've never worked at Dawson Place because Dawson Place, the entity, didn't exist while you were a prosecutor with the Special Assault Unit. So they proceed from a fundamentally false and I think willfully blind position about the entity that they have sued. Now, in asking for you to be recused for cause, the plaintiffs bear an incredibly high burden. There is a presumption that you have discharged your duties as a judge with regularity, with fairness. I think there is nothing that they have pointed to in the record of this case that casts a shadow of a doubt on that. There is nothing that they have pointed to in their motions which has any validity to the contention that you have been biased or handled this in an improper manner. Indeed, virtually all of the materials that they submitted have nothing to do with you. The deposition that they keep talking about for Adam Cornell did not mention you one time. Ms. Shavlik's latest materials claim that they have attached the deposition of Adam Cornell, and now she is alleging that there was a deposition of Mr. Cornell in some other case. Again, that's not provided. Even if it was, whether Mr. Cornell worked with two law enforcement officers from the sheriff's office in his capacity as a deputy prosecutor while his office was at Dawson Place has nothing to do with your ability to fairly and impartially decide the issues that you decided in this case. So I believe that they have failed to address the law. They have failed to address the facts. They simply have made ad hominem attacks which are blatantly false. And for the record, I'd like to go through them. On page 2, at lines 4 to 5 of her motion, Ms. Shavlik alleges that you issued your ruling granting $3,000 in attorney's fees as without warning, notice, or an opportunity to respond to a motionless order. That is categorically and demonstrably false. We moved on December 10th for attorney's fees, citing the frivolous action statute and CR 11. Our brief mentioned the fact that she had been found to have been harassing Mr. Fontenot and Ms. Conley, and that was part of the basis for CR 11 sanctions. There was a hearing in this very courtroom, attended by Ms. Shavlik, in which you heard that motion. You took it under advisement and issued a written ruling later. This in no way is a order that was without warning, notice, or opportunity to respond. There are allegations which are completely unsupported that follow. At lines 5 to 7 of page 2, she claims that you removed records from her filing. There is no shred of support in any of the exhibits that she has put forward. There is no sworn testimony to that. It is completely unsupported. At lines 7 to 9, she continues to say that you signed an order that was somehow improperly filed in a different case number, apparently with the intent to hide it from her for purposes of appeal. Well, obviously, if she knows about it, it wasn't hidden very well. And again, this allegation is completely unsupported in the record, and there is no evidence whatsoever to believe that you did anything improperly. She claims that she learned of your bias somehow through these depositions. The deposition of Mr. Conley in this matter, or Mr. Cornell in this matter, occurred before you even heard the motion for summary judgment. All of the exhibits that she has put forward predate the motion for summary judgment. She had all the information she needed if she wanted to raise an objection. She didn't. She doesn't point to these depositions or cite any specific place where she supposedly learned that you were biased or unfairly prejudiced. Again, the statement that she learned of something about your fairness in these depositions is completely false. On page 3, at lines 11 to 12, as part of her subjoined declaration, she claims that you did not disclose your relationship to the defendant. Yet she attaches the court's minutes where you do disclose that relationship. And when we were in this courtroom for the motion to change venue, you began by informing all the parties, including Mr. West and Ms. Shavlik, that you had worked for the Special Assault Unit. The Special Assault Unit is part of the Prosecuting Attorney's Office. And when you were in the Prosecuting Attorney's Office, that unit was created a long time ago, I believe, when Seth Dawson was the prosecutor. And there's lots of prosecutors who have worked for that. What she fails to disclose is that you told everybody that, and that it later ended up at Dawson Place. The fact that a unit that you once worked for changed locations and is now officed at Dawson Place does not reflect on your ability to decide the matters in this case. And the fact that you did disclose it gave her an opportunity to object. She failed to do that. In her reply materials, she claims that you worked at Dawson Place. Again, you became a judge in 2008. January 2009. You were elected in 2008. Dawson Place wasn't incorporated at that time. The Child Advocacy Center was sort of in the planning stages, but it didn't open. And to my knowledge, you've never been officed at Dawson Place, whether it was at its current location or at its previous location in the bank building. She fails to attach the evidence that she claims supports this. These are all violations of CR 11 and merit additional sanctions. There's no reason that we're here arguing about this. There's no reason that that this matter should be considered. She had every opportunity to raise these and failed to do so. She didn't raise them when you decided the motion to change venue. That was opportunity number 1. She didn't raise any objection to your deciding the motion for summary judgment. That was opportunity number 2. She filed a motion for reconsideration. She didn't raise your fairness in that motion. That was opportunity number 3. She didn't raise them in her response to our attorney's fees motion. That was opportunity number 4. Opportunity number 5 was the reconsideration motion she filed after you granted, in part, the motion for attorney's fees and awarded $3,000 to Dawson Place. So she's had 6 different opportunities to raise it and never did. She only has raised this after you have issued an adverse decision on summary judgment and after you have issued a sanction against her. Sanctions based largely on her deposition of Adam Cornell and on the findings of Judge Weiss that she sought to depose Ms. Connolly and Mr. Fontenot for purposes of harassing them. That's not your finding, that's Judge Weiss's finding. You agreed with that finding in awarding sanctions. You described your reasoning carefully, and she had every opportunity to raise that in reconsideration. Her remedy is now to raise that on appeal, not to seek to disqualify you based on these completely fabricated charges of bias and prejudice. We ask that you not only deny this motion, we ask that you award us the cost of having to respond to it. And frankly, Your Honor, I think the contemptuous statements that are in her written pleadings are a basis for an additional sanction, not to Dawson Place, but to protect the integrity of the court. Because what she's doing here is an assault and affront to the administration of justice and to the fairness of our judicial institutions. To base it on the kinds of false statements that she has, I think, is a basis for a sanction directed to the court. And with that, I ask you to deny the motion to recuse. Thank you.
All right, thank you, Mr. Myers. And what is the cost of the response?
Your Honor, the cost of response, I spent about 4 hours responding to the briefing and another 2 hours to come up here and argue this motion, 6 hours at $225 an hour. That would be what I would ask.
All right. Thank you, Mr. Myers. Ms. Shavlik, you may speak again with regard to the motion to recuse, but you also may, if you wish, address the motion for CR 11 sanctions.
Okay. Your Honor, Jeffrey Myers never put in SCR 11 for sanctions. That is what I was referring to as a motionless order. If you look back at his orders that he filed, there were no sanctions that he asked for. He didn't ask for you to sanction me. You did that all by yourself without any motion before you. And that is what I was speaking of. The sanctions were not even asked for in his motions. Were you able to locate that?
His response, page 7.
His response, when he filed his motion, he did not ask for that. The response was never given to me.
Your Honor, I believe she's referring to our attorney's fees motion filed in December.
Yes, sir.
Oh, okay. I may have misunderstood, but I wanted to make sure you also had an opportunity to respond to Mr. Myers' request for CR 11 sanctions for this, and I'm referring to his request on page 7 of his response to your motion. So I just wanted to make sure I heard everything you wanted to say, including, if you wish, a response to the motion that he has made just now orally, as well as in writing on page 7.
Thank you. I was going to go in order. And the CR 11 sanctions that he filed in December, he did not ask for CR 11 sanctions. And that is the order that you were referring to when you made your order on February 1st. There was no sanctions in front of you at that time. He did not ask for sanctions. There was no motion for you to sanction me. There was no opportunity for me to respond. There was no notice that I was going to be subject to a sanction. When there's no notice, I had no opportunity to respond. I had no meaningful opportunity to argue that. Okay? And he said that I said that I found out through Adam Cornell that you were prejudiced in this case. I actually found out through the discoveries and asking questions led me to search other cases. And when I searched other cases, I came across Raymond Baines, and there's many other cases where I read that you have personal knowledge of what goes on inside of Dawson Place, and you also have that history of working for Dawson Place. And it was in the order, it even says that I have worked inside of Dawson Place, and that's what I read. So it kind of made me think that you're actually, the only way I'll know that is if I question you, and if you become a witness in the case rather than a judge, because he's assuming, I'm assuming, that maybe we need to find out. I mean, is that fair for me to have to come before a judge that has a personal relationship with Dawson Place, whether it's past working relationships or past capacities of friendships or personal knowledge of things that are going on. That's not fair to me. We deserve a right to confront our justice system without any. I did everything legally. I got my subpoena legally. I got everything. I did it the proper way. I never insulted anyone. I just served my justice. I cannot say that he can tell you how I make my argument, but it's in no way has it ever been an intent to assault the justice system. Actually, I'm asking the justice system to serve itself and do the right thing. And it is in no way meaning that I should be punished for coming to my government and asking, where does my tax dollars go? Where does the $13 million that goes to Dawson Place, where does that go? I'm a taxpayer. I should have the right to confront my government and say, are the prosecutors and the sheriff supposed to work together inside of a Dawson Place where they collect evidence and use it in a crime? And then our court system has found that that's not giving people due process. And I'm here for people who cannot stand up for for themselves. And I think it's wrong, and I'm standing up for justice. And I should have that opportunity to do that without being penalized for doing it in the proper manner. The cost as far as the CR 11 sanctions today, Your Honor, I asked Jeffrey Myers if he would please we would agree to a motion to stay until the Division Court of Appeals decides on that appeal that I have on the sanctions that you put against me. I filed a separate appeal. That is going before Division 1 hearing. They're going to make that decision whether or not I get an opportunity to have that corrected. I think that is serving justice to wait until they've made that decision. I should at least be allowed that opportunity to find out if it's fair or not from another perspective. I asked before we even set a court date, I asked if he would agree to a motion to stay. And then that's when he came and filed this hearing today. Is instead of agreeing to the motion to save everyone cost, nobody would be out a cent. It's never my intention. I've always tried to work with Jeffrey Myers. It is not my intention to cost anyone any more money. I went to him, I asked him to agree to the motion to stay, and he absolutely refused and then filed this hearing today. He filed the hearing for the sanctions today at 1 o'clock. So that is his, and I don't think I should be sanctioned for him to file his motion for a presentation. That's what he did. So that's.
Now, I will make sure you have an opportunity to respond to his presentation. Was there anything further you wanted to say concerning the motion to recuse and Mr. Myers' motion for CR 11 sanctions in connection with your motion to recuse?
No.
Okay. All right. Thank you, Ms. Shavlik. All right. With regard to the motion to recuse, I never did work at Dawson Place, and I never said that I did. The motion to recuse is denied. With regard to the CR 11 sanctions motion, the motion to recuse was based on unsupported allegations of fact. It does violate CR 11. I will award $1,350 attorney's fees to Dawson Place for having to respond to a motion that was not based on any good faith recitations of fact. And now it's time for the motion, or I suppose I should say the presentation. Mr. Myers, this one is yours. Was there anything you wish to say in aid of your presentation? I do have the working copy of your proposed judgment, and I'm not saying much, but I'm just checking to see if there's anything you wish to say in aid of your presentation.
Your Honor, the only thing I would ask is that the amounts be amended and that we interlineate the award which you just made. I have a proposed order denying the motion to recuse, which I'll show to Ms. Shavlik. It's a simple denial of the motion, and then notes that the plaintiff is sanctioned $1,300 for violation of CR 11 in bringing this motion. And I would ask that $1,300 be added to the principal amount of the judgment.
Ms. Shavlik, it's $50 less than my calculations. Do you have any?
Was it?
No, I have no objections.
Yeah, according to my
Yeah,
calculator,
appeals.
it was $1,350.
$1,350?
I wasn't.
I may have misheard, Your Honor. I would like to then...
You indicated your rate of pay is $225. That is how much you cost Dawson Place.
That's correct.
$225 per hour. And you indicated
6 hours.
6 hours. I get $1,350.
$1,350, Your Honor. I just didn't, when you announced the amount, I didn't hear the 50.
Oh, okay. Ms. Shavlik.
I'm just going to appeal it. There's nothing really I can say that would help.
All right. Well, based on what Mr. Myers said, and it was in keeping with what he said before concerning his rate of pay, and based on his statement that this response in writing and orally required 6 hours, which under the circumstances, not a great deal of time. I will accept those representations and award $1,350. May well have been more than that, but at any rate, that's what I'm going to award. Sign the judgment, and that does conclude this matter. Have a good afternoon.
Your Honor, actually, I would like to hand you a different form of judgment that simply notes the amount is $4,350. Plaintiff was also sanctioned $1,350 for bringing a frivolous, unsupported motion to recuse on March 9, 2018.
All right, well, I want to make sure that Ms. Shavlik has an opportunity to review that fully, so I'll tell you what. And Ms. Shavlik, you can take your time with that.
Really? Is this different than the one that you just signed? Or why are we
I haven't
doing
seen that, so I don't know. I'm just
Your Honor,
saying.
it's the same form of judgment. It
Why are we
changes the
doing
amounts
two?
to reflect the court's rulings today.
Oh, okay.
Why are we doing two? Is it two?
No, I'm asking him to enter this one instead of the one that he just signed.
So, all right, I just signed the one.
There's a motion denying the recusal, and then there is a judgment that we have asked the court to enter, which begins the post-judgment
Okay,
interest.
this is merely an order.
Okay, the order was what you signed.
Okay.
I was confused.
Okay. Well, okay, and I use the word judgment, but in fact, you are proposing to use a separate order and a separate judgment.
Yes, Your Honor.
Okay. So what you have, Ms. Shavlik, is the actual judgment. You, I believe, already saw the order ahead of time. But that is the judgment. I do not know whether you've seen the judgment. So you should have an opportunity to review the judgment, and I'm not going to require you to rush through it. If you've not seen, has she seen this before?
She saw the form of judgment when it was $3,000.
I did not see this.
I've interlineated the calculations to bring
I
it to
haven't seen
$4,350 today. It was attached to the notice of presentation.
And if either of you, or both of you like, you are certainly welcome to use the court's calculator.
I trust your math.
All right, well, there it is, in case anybody wants to use it. You can check the math.
Did Jeffrey Myers submit statements There's no statements. He just says whatever he wants. I think that we should have statements which show us his billing for his $1,300. I mean, why shouldn't I be allowed to see a statement?
Oh, well, I guess we could do that, but what if he spends time doing that and then bills for that time?
Okay, Mr. Appel, are you saying that I shouldn't ask for a statement?
No,
I
not at
think
all.
it's fair that we get a statement, don't you? This is,
Did you understand my question?
how about we do the $3,000?
Ms. Shavlik, did you understand my question?
I guess I didn't.
Okay, here's my question. And this is really, this is not a question that contemplates any particular answer from you, but I do think you might wish to consider this. If I say, okay, fine, we'll wait to find out if 6 hours is exactly what he billed, and then, Mr. Myers, go back to your office and prepare an actual bill. I could do that. However, if I were to do that and he spent time doing that, it may well be that the judgment will be even higher because of his time doing that. So
Okay.
I leave it to you. If you want me to order him to go and prepare a bill, I will do that. But I want you to at least bear in mind the possible consequence of that. I think it's only fair.
So I'm going to have a consequence for him submitting a bill?
Your Honor, in addition to that, when I was representing to the court that I spent 4 hours responding and additional 2 hours coming up here today, I was trying to be conservative and fair. If I have to go back and provide an actual bill, I will ask for the full compensation for all the time spent, including the time spent by my paralegal, and I guarantee you it will be more than $1,350.
Well,
I think $1,350 is a reasonable sanction, and that's what I asked for. But if we have to go through that, I'm entitled to fees associated with proving the costs, and you're correct, that would involve additional time, it would involve another hearing coming.
I will hear from Ms. Shavlik on this, but in the end, I'm going to decide what I'm going to sign. And I might sign that thing right now, regardless of what else is going on or what else might go on, or I might not. Ms. Shavlik, did you wish to be heard any further?
I simply just wanted to see a statement. I came here today for a $3,000 presentation that turned into $4,350. I don't think that's proper. Do I lose my right for an appeal for the $1,350? I mean, you're lumping this together, and I don't know that that's fair or right. Why would you just rush this in like that? I feel like it's fair that we should keep it the same, and then I have an opportunity to do the other separately.
Okay.
Or am I going to have to redo my appeal again to include this $1,350? Because I want to appeal your decision. I feel it's unfair and I want to appeal it.
Well, Mr. Myers, I have done enough of this work to be able to make a decision as to what is reasonable and perhaps even modest. And I think 6 hours is reasonable and perhaps even modest. And I'm not going to belabor this any longer. I will sign a judgment for $4,350, and then that will be the end of it.
Thank you, Your Honor.
Judgment is approved. Good afternoon. Court is in recess.
All right.
Would you have the rules of professional conduct that you don't have to create an invoice for the time?
They do that for the judges.
I just requested it from Dawson Place.
Ridiculous.
Ma'am, you're not a party to this action. Or are you?
Oh, no. Not at all, but I can't wait to see the public record on the invoice. And I think the bar is